If you are the trustee of your family estate and you need to sell the family home, do you know what you're supposed to do step by step? This process can be very overwhelming and full of family conflicts. In this video, I will try to organize the process for you, and I tell you where you can access other resources at the end of this video. My name is Dar Marden. I'm a CPA and a realtor in Orange County, and I specialize in trust sales. I am not an attorney, and this is not legal advice. It's educational in nature. If you need to consult an estate attorney, I can refer you to one. Let's dive into the steps that will help you during this process. Step 1, the trustee takes control and establishes authority. When the parent or parents pass away, the trustee, whoever is named in the trust, takes over. The trustee has legal authority to execute the trust based on the instruction that is written in the trust document. That is the trustee's job. It creates clarity, authority, and an action plan. Step 2, decide how and when to sell. The trustee must create the process. The goal is to get the best outcome without turning it into chaos. There are 5 areas that the trustee should get clarity on immediately. First, ensure that the house is actually placed in the trust, and if it's not, what they need to do to fix that. If that's the case, you need to have an attorney to help you with that. Second, review the property profile or the title report for any liens on the property, such as taxes, mortgages, home equity lines of credit, and any mechanic liens. Third, get yourself a realtor who understands the trust sales and they can guide you through that process. Fourth, determine the home condition and the best path for the sale. You can get help from your realtor to tell you what is the best approach to sell the house. Sell it as is or do some upgrades. And finally, the fifth, determine the timing based on the trust instruction, family dynamics, and the home condition. Step 3, communicate, communicate, communicate. One of the biggest mistakes families make is rely on verbal conversations and assumptions. That's where the conflicts begin. Put all your findings and decisions in writing and communicate it to everybody, to all the heirs. Remember, as a trustee, you're in charge. You make the decisions and you must communicate the path clearly. So here is the clean approach. The trustee prepares a simple written summary document for the heirs that says, based on the trust instructions and his review, how the house sale will be handled and how the sales proceeds will be distributed. Isn't that clean? Isn't that clear? That's exactly what we want to do. We want to have a clean path forward that everybody knows what's coming up and how everything is going to work out. Step 4, that's a little complicated. It's taxes and a step up in basis. There is a concept in taxation called step up in basis that applies in inheritance cases. In plain English, when someone passes away, the home's value for tax purposes is reset to the fair market value on the date of death. If the home was bought years ago for a low number or a low value, and today it's worth much, much more, the step up in basis can dramatically reduce the capital gains taxes when the home is sold. That's a big deal. But it needs to be handled correctly and not to be messed up. It needs to be documented properly. And I'm going to explain that to you. If a home is sold near the date of death, in most cases, there will be no taxes due. If the home is sold at a significantly later date and the selling proceeds less repairs and selling costs, are more than the value of the home at the date of death, then there might be some taxes due. Step 5 is documenting the value of the home, doing it via an appraisal or a broker value opinion. To use this step-up in basis properly, you need support for the fair market value of the home on the date of death. An appraisal is the strongest support. The other alternative is a qualified broker statement of value with a strong documentation, comparable sales, adjustments, photos, and a clear explanation that can support the fair market value. Your expert realtor can help you with that. The key is simple. Don't guess. Don't rely on random online estimates like Zillow because they don't know the condition of your home inside. Use the professionals to actually value your home. Online estimates like Zillow or Redfin are mostly wrong, and if they undervalue your home, you might end up paying taxes when you sell the home. Step 6, who files the taxes and how is it reported? If the trust sells the house, then the trust will file a fiduciary return. It's called Form 1041, and beneficiaries receive the K1, and the income passes through the K1 to the beneficiaries. This is the most common way, and all the taxes are handled through that process. And again, as I said, in most cases, you don't own any taxes on an inherited home. If a home is distributed out to the heirs first, then they sell the home, which is really messy. Then you need to report that income on Form 8949 on a Schedule D. This is not very common, and I honestly don't recommend that to you. It's such a mess. This process can be complicated, and you might need guidance from a CPA or an estate attorney based on your situation. Let me know. I can refer you to people that do that work. And here's my final thought. The biggest mistakes families make are about communication, lack of clarity, and guessing. Get an expert realtor who understands this process to help you. It will save you so much time, agony, and money. I cannot overemphasize that. I'm going to put a link to my blog that discusses this topic. You can actually use that for some of your reference points. If you do the things we discussed here, it will reduce the conflict, it will protect you, it will improve your family relationships, and it will protect your financial outcome. If you need any help in this process, contact me. Let's use this information to protect you, and let's do something great together. The link to connect with me is in the description. Take care of yourself.